Welcome everyone to this In-House in Focus webinar. Today we'll be looking at the issue of whistleblowing. If you don't know me, so I'm going to cough. If you don't know me, I'm Rachel Higgs and I cough, and I head up one of our commercial disputes teams. And today I'm obviously joined by James Kidd and Kate Ledwidge, partner and senior associate respectively in an employment group. This session is being recorded, and the recording plus the slides that we're going to be using will be sent to you in the next couple of days. If you've got questions, can you please put those questions in the Q&A box? Don't use the chat function because we're using that internally. So put them in the Q&A box. Your questions or comments will show up as anonymous to everyone other than James, Kate and me. You can use the anonymous function to anonymize your questions even from James, Kate and me. But of course, if we don't then get round to answering that question because we're short of time, then we won't be able to follow up with you because we won't know who you are. You will get a survey form at the end of the session. It will pop up once the session has closed. Please complete it so that we can follow up on your comments, your suggestions, and in particular, your requests for future topics to be covered. That's really useful information for us. We will aim to speak for 45 minutes. We'll have 15 minutes for questions, and I will be quite ruthless in the cut-off, so we will be ending at 11 o'clock prompt. So without further ado, let me hand over to James and Kate.
Thank you, Rachel. That just tells you everybody what you did. So using the Q&A function, if you do want Rachel to serenade us with some Spice Girls songs, I'll take a majority. There's currently, what, 75 people will take a majority. Is that all right, Rachel? If we get more than 37
that's great, but I may be using my powers of delegation now.
It's not all about when two become one, is that right? Something like that. Right. Moving on to matters slightly more prosaic. So thank you for the introduction. So Kate and I are just going to talk to you this morning about three core topics, as you can see on the slide. A little bit about the new whistleblowing directive that's coming through, some work on where we are in the UK and a couple of recent cases, and then just if you are part of a multinational, what you need to think about in terms of the UK and then the European Union. And Kate rightly called me up yesterday for sometimes saying Europe rather than European Union, and said her dad would always correct her if that was the case. Is that right, Kate? Yeah, very much so. Pedant extraordinaire, yeah. And if you're watching Mr. Ledwidge, we apologise in advance. So this is all about whistleblowing, and we thought it might be useful if we just reminded you of the high-level principles of where we are with whistleblowing in the UK. So this is our Graham with a quick reminder. Kate got my cultural reference yesterday, didn't you? I did, indeed. Rachel will get that too, right?
Yes.
But Kate, interestingly, didn't get the reference to when Blind Date had not just the young people who were going on the dates, but they went with the elder generation who were going on the dates, and she had no memory of that, but obviously wiped that experience. Rachel's looking like maybe. Okay, so moving on, enough Jamesy things. So if you are an employer or a worker in the UK, then you are covered. Just question myself, workers covered, aren't they, Kate, currently? Yeah, they are. Yeah, thank you for that. Sorry, good start. Then you are covered from day one in terms of whistleblower protection. So that's in terms of you have the protection if you're subjected to a detriment, that's a phrase you'll hear today, or subjected to dismissal. So a detriment is stuff that may happen to you up to but excluding dismissal, and then possibly post-dismissal, whereas obviously dismissal is dismissal, and it would be automatically unfair. You don't need 2 years service to be able to claim that. The attraction of the whistleblowing protection, if you're going to bring a tribunal claim, is that the unfair dismissal cap, i.e. a year's money or 87,000, whichever is lower, is removed, so it's ongoing loss of earnings. There is injury to feelings available for detriment claims. Now, there is something called interim relief. Now, interim relief is where if you believe that you have been dismissed due to being a whistleblower, you can apply to the tribunal and say, I should not be penalised further and I should be reinstated for the purposes of salary up until the hearing. It's a very powerful weapon used by claimants. So you're asking for a judge to make a very early analysis of the prospects of you succeeding, and if the judge says yes, then you're reinstated for the purposes of salary, which can be, at the moment with the tribunal system, perhaps 18 months to 2 years. It doesn't mean that you will win at the subsequent hearing, but it just means that you've satisfied that initial test. As I say, a very powerful weapon when used by claimants. To get to win in a whistleblowing claim, you need to have made a qualifying disclosure and a protected disclosure. A qualifying disclosure basically is where you have said there is malpractice in essence going on within certain categories. You've either made a verbal or written disclosure to that effect, and you've done it to either your employer in the first instance or certain categories of other people. You can't go straight to the Daily Mail unless it's in extreme circumstances. And if you do all those things, you then get the protection. And lastly, there is something called the public interest test. So if Kate says to me, James, they're dumping chemicals in the Wensum, and it just affects her, bad example, but you know what I mean, then she's failed because it's not in the public interest. But if it actually affects lots of people, which it would do if we're dumping chemicals into the Wensum, then she's passed what's called the public interest test, which is basically, it can't just be about you, it must be about you and others. We're not dumping any chemicals in the Wensum, can I just clarify? Okay. So we now have, we have the existing legislation in the UK, but we now have coming on the horizon, very shortly on the horizon, the new directive from Europe. So we've made the point it's 40 pages. That's not exceptionally long for a European directive, and the equivalent data protection one is much longer, funnily enough. So adopted a couple of years ago, due to be implemented in just over 2 months' time. We're going to come on to, Kate's going to deal with whether we have to implement it or not. There is a 2-year grace period if you are in a small business, effectively between 50 and 250. And it's fair to say that some member states have already implemented it, but the majority, as I read the other day, have not. So patchy implementation so far. And Kate's now going to talk to you about how the new directive differs from our legislation.
Thanks, James. So we thought it would be useful to do a bit of a broad comparison between current UK whistleblower protection, which James has just summarised for everyone, and this new EU directive. And there are a few sort of quite important differences between the two levels of protection. So one of the big ones is that the new directive in the EU very much expands the protected group of potential whistleblowers, particularly when compared to the group under UK law, which, as James explained, currently covers employees and workers only. It does not cover self-employed individuals, and it doesn't even cover applicants for jobs, apart from a very specific exception in relation to NHS applicants. So basically, you're only protected if you are subjected to a detriment or dismissed by a current or former employer of yours. Under the new EU directive, as well as employees and workers, which of course are still covered, the protection extends to self-employed individuals and a very sort of big catch-all category known as facilitators, which means anyone who acquired information in a work-related context, even if they're not sort of directly connected with the business. So that has the potential to be really wide in theory. So it could cover shareholders, volunteers, anyone working for a contractor, subcontractors, suppliers, and also potentially people who are even more removed, but they might just be assisting the whistleblower or supporting the whistleblower somehow. And so if they suffered any sort of detriment or retaliation, in theory, they could be covered too. So that's quite a big expansion on what we're used to. The other big difference is the definition of what would be, in UK sort of parlance, a protected disclosure for a whistleblower, which interestingly is narrower under the EU directive than we're used to in the UK. So, as James said, qualifying disclosure in the UK is a disclosure of any information. There's the public interest test, and the disclosure has to show a specified type of wrongdoing or failure on the part of the employer. So there are the obvious ones, like if there was potential criminal activity, potential environmental damage, safety issues, but we have a very broad catch-all category in our definition of a disclosure, which is a breach of any legal obligation, which has been held to be quite wide. In theory, could include, for example, a breach of a contract, which contains a legal obligation, provided it passed the other tests. And it certainly includes breaches of UK employment law as well. So under the EU directive, only breaches of specified EU legislation are covered, which is a much narrower definition than we're used to. And we suspect it's going to be potentially complicated, and some member states who will already have definitions of disclosures which might be wider than this definition. So individual member states might have to sort of gold plate the EU directive and work out how it's all going to work in harmony under local law. A final point of comparison on the next slide is the approach to take when someone does make a whistleblowing report. So the EU directive is quite prescriptive in terms of what businesses should do to establish appropriate internal channels for people to make a complaint. So, for example, businesses need to have channels that allow for multiple different ways to make a whistleblowing report. So written reports, spoken reports, a face-to-face meeting with someone who's designated to receive whistleblowing reports. It's also prescribed that those channels must preserve the confidentiality, anonymity of the person who's making the report. And also businesses must acknowledge a whistleblowing report no later than 7 days after it's made, and then must provide feedback to the whistleblower within a reasonable time, i.e. as soon as they reasonably can, and certainly no later than 3 months after they've acknowledged the report. So you'll probably know that these aren't strict requirements. There aren't sort of very prescribed reporting and process requirements in relation to whistleblowing under UK legislation. Just a caveat, aside from some specific exceptions. So, for example, if a business is covered by the FCA whistleblowing regime, that is more prescriptive, but for most businesses, it's not so prescriptive. That said, a lot of the elements of the EU directive on the channels for reporting whistleblowing are considered best practice in the UK anyway. For example, you're probably familiar with offering in a whistleblowing policy confidentiality and anonymity where possible, because the biggest focus of the UK legislation is trying to prevent retaliation for whistleblowers so that people feel comfortable in making a report. And so best practice in the UK probably doesn't feel too different from what the EU directive is trying to get at with those requirements. But broadly, the sort of aims and concepts under both regimes, current UK and the new EU regime, are similar. So it's the whole concept around protecting against victimisation for whistleblowers in the UK. You can't suffer from a detriment for making a protected disclosure. Under the directive, you're protected against any form of retaliation, is their language, as the result of making a disclosure. So the aims are very similar, of course. So now on to the big question that I'm sure you're all waiting for the answer for. Do we have to mirror this in the UK? There's a big spoiler at the top of the slide. Short answer is no. So we're no longer a member state, so we don't have an obligation to implement it as a member state. There are some what are called non-regression provisions in the EU trade agreement, but they won't catch this particular piece of legislation purely because it wasn't in place, wasn't implemented prior to the end of 2020. If it had been implemented before, it might have been different, but as it is, we don't have an obligation to mirror all those requirements in the UK.
Thank you, Kate. So I'm going to pick up a couple of questions, if I may, Rachel, now. Is that all right?
Yes, I wasn't sure whether to leave those to the end, James, but they relate mainly to the bit that you did earlier, and particularly throwing chemicals into the Wensum and whether or not that's in public interest. So, do you want to read them out?
Yeah, that's fine. So Peter says, if you're dismissed in the tribunal order, your reinstatement for salary purposes until the trial. If you lose a trial, do you have to pay the salary you receive back? Short answer, no. If you satisfied a judge at the first hearing that you should be reinstated for salary purposes, if you lose subsequently, you keep the money. You can see again why it's a powerful weapon. And then we have an anonymous question that says, how broad does public interest need to be? Does it cover harm to investors, for example? And how does that interact with crowdfunding? So it does need to affect other people. So if you are making a whistleblowing complaint just about your level of bonus, you're going to fail your public interest test. If it's about the level of bonus for you and all of your colleagues, you're going to satisfy the public interest test. So if you are making a whistleblowing complaint in a crowdfunding situation where you say, trying to think of a particular example, where the money is being misused, for example, and therefore shareholders are being not getting the right money, or they're not getting the right information, perhaps, and that therefore affects all of those shareholders, so you're doing it on their behalf, then yes, you've got to satisfy the public interest, because it affects more than just you. Okay, we will pick up questions as we go through, depending on the points and the extent of the questions, but I like to do it that way. Right. So recent UK developments. Thank you to Kate for taking us through the directive. So whilst we're not going to have to do it, I think it's just worth just spending a moment on where we are at the moment. So where is the UK government on this? So let's take our minds back to 2013. So that's when we had public concern at work, who were saying we need to review the effectiveness of whistleblowing in the workplace. And there's been a bit of tinkering since. So as Kate mentioned, we've got extensions to job applicants, we've got the regulatory bodies. In 2019, we had the House of Commons who said, there needs to be a fundamental review of whistleblowing. And the government said, no, thank you very much. The current legislation is fine, even though the House of Commons said they needed to do more. As recently as March this year, we had, now Kate and I disagree on the pronunciation of this, so it's the Department for the Business, Energy and Industrial Strategy, which Kate describes as pronounced as
BEIS is what I've always said.
BEIS, which I always think it looks like it should be BEIS, but anyway, BEIS. They took data from Protect. So Protect is that department's whistleblowing advice service. And in the 6-month period between September last year and March this year, Kate, what do you think the number of people, as expressed as a percentage, were saying, I've whistleblown and been dismissed?
I will guess 10%.
Very good, because you know the answer. So that's
I was trying to act there, James. Can't believe you revealed it.
And the BAFTA goes to...
Thanks.
Yes, so rather alarmingly, 1 in 4 people contacting that Protect advice line were saying that they had been dismissed as a result of raising a protected disclosure. So 25% of people. Now, I would bet, given that that was September to March, they were raising health and safety issues in relation to COVID, and were saying, no doubt, it's not safe to be in the workplace. That would be, I think, an educated guess. But I think that's a very high percentage for them then to be dismissed as a result of making those complaints. I think that that's running counter to what we see on a day-to-day basis, which is, whoa, that we do get whistleblowing claims, but it's not 1 in 4 people being dismissed as a result of raising whistleblowing incidents or complaints. So I think what we've got is a no commitment, as it says on the side, to implement the legislation at the moment. So UK law still applies, but as we'll come on to later, what do you do if you're a multinational business? Staying with UK, so for many years we've had BEIS guidance, and I'll take you through some highlights of that guidance in a second. In 2016, the government announced that there would be a thorough review of the 2013 guidance, and because they wanted to enhance management of risks and reporting of wrongdoing. And guess what happened as a result of that commitment in 2016? Exactly nothing. So again, lots of talk, no action. What does the guidance therefore say from 2013? It makes 5 key points, which I'll just take you through. So 1, you need to make staff aware under the guidance of how they can easily access a whistleblowing policy. 2, you should be training staff, this is an important point, training staff on how to make a whistleblowing complaint, and then managers on how to deal with it. I think that's a shift. Normally you'd say, well, how do we work out, how do we deal with it? Actually, this is upskilling your staff about how to go about making the complaint in the first place or speaking up. 3, you need to develop a culture where staff feel safe to make disclosures, know who to go to, and feel confident there will be no reprisals, no detriment suffered as a result. 4, that you undertake to protect the identity of the whistleblower and also keep them informed as a result of going through the process. And 5, settlement agreements. So settlement agreements are a fact of life in employment law. There are strict provisions on how much you can stop somebody continuing to make disclosures in the future, having signed a settlement agreement. Now, those obligations exist on everybody, but when we are advising as solicitors, as officers of the court, subject to our regulatory body, the SRA, are subject to tighter restrictions in that respect. So I think the guidance is a really good starting point. If you haven't read it recently, dust down your policy, have a look at it. So should we deal with the question what's coming?
Yeah, James, yes, you've seen the question that's cropped up, if you could deal with that.
Okay, I'm going to push that to Kate.
Okay, Kate, does the annual reporting requirement only apply to organisations who employ more than 250 employees?
I don't know which annual reporting, does this refer to what you just discussed, James?
Yeah, I wasn't sure of the answer to that, so we will
just
investigate.
To do with the BEIS information. Is that what that refers to?
I don't know. Right, rather than us floundering around.
Yeah, anonymous attendee. I
apologize.
Call upon the person to elaborate further. But if you could explain in a little more detail what the query is and the annual reporting requirement, then we'll look into that.
Or alternatively, resend it with your name, and we'll follow up later.
Yeah, sure.
Right, Kate. Here's our Kate with some first of our case law updates.
Yeah, and the first one actually is a bit of a quick reminder, just to follow on the blind date theme that James seems to be keen on today. We thought it would be useful just to, so there are 2 cases which are a lot more recent, very up to date, so worth explaining to you, but we thought it's always worth a reminder to talk about Ozypoff, which was made quite a stir a couple of years ago. It's a 2018 case, but it's a good reminder of almost sort of very worst case scenario that can happen if you have a whistleblowing issue in your organisation. So the case involved an employee, Mr. Ozypoff, and 2 non-executive directors. And Mr. Ozypoff had made protected disclosures during his employment relating to, they were sort of an oil exploration business. So he made some disclosures relating to contracts in Niger. So these 2 non-exec directors, as a result of these disclosures, seemed to sort of orchestrate Mr. Ozypoff's dismissal. They ran the process these two non-exec directors implemented a decision to dismiss him as a result. Unsurprisingly, after his dismissal, Mr. Osipov brought an unfair dismissal claim, automatic unfair dismissal claim against his employer, International Petroleum Limited. But interestingly, he also brought whistleblowing detriment claims against the two individual non-exec directors, which is something that you can do under UK law. It's relatively underutilised, I would say, in practice by claimants, but it is something they might know about. So when the case was running, the two non-exec directors sought to avoid personal liability for a detriment by trying to rely on an element of UK whistleblower legislation that says an employee can't bring a detriment claim where the detriment they're complaining of in question amounts to a dismissal. So basically, it's an automatic unfair dismissal claim for whistleblowing only if the dismissal is the thing you're complaining about. Their argument was that their actions, all related to the dismissal, involved the dismissal, and so they were excluded from being personally liable for a detriment. It had to just be an unfair dismissal claim, according to them. Ultimately, it went sort of through various layers of the courts, but ultimately it was decided that Mr. Osipov could, in fact, bring both of those claims. He could bring a claim against the individual non-exec directors. And they distinguish between the act of dismissal itself and effectively the conduct of the two non-exec directors in orchestrating the dismissal, their personal conduct and treatment of Mr. Osipov. Everything they did, the way they behaved around the dismissal could in itself amount to a detriment. And he ultimately ended up succeeding in both claims. There was a bit of a quirk, as the slide says, in that the employer, the company, actually went into liquidation. So there was no money left in the employer. So even though he succeeded in his unfair dismissal claim and his detriment claim, the court decided that the non-exec directors were personally liable for the losses flowing from their actions, and it was a joint and several liability with the employing company, which was insolvent, so they were the only people left standing. And the losses flowing from all of this totaled over £2 million, which they were personally liable for, which was probably a very bad day for those individuals. So in terms of lessons to be learned from this case, I think it's just always worth remembering that personal liability can potentially flow, particularly I would say for sort of decision makers and people dealing with whistleblowing reports, and it might just be a useful case to remind some senior managers of now and again if you ever get any pushback.
Thank you, Kate. I had Osipov quoted at me a couple of months ago, and we haven't seen a flood of claims where it's against the company and then individual named respondents following Osipov, but it clearly is out there, and it's like interim relief. It's a very powerful tool, particularly if you want to try and unlock some greater compensation and sharpen people's minds. It's like naming individual respondents in a discrimination claim. It's a similar vein, isn't it? Okay, so we're going to go on now to talk about Jhuti. I think that's how you pronounce it. This is a somewhat sad case. It's akin to a disability claim. So sometimes you'll say in a disability claim, we didn't know that Fred or Ginger was disabled, so therefore we can't be criticised for our acts and omissions later when we dismiss or subject this person to a detriment, because how are we to know that they were disabled? And in this case, this is about a dismissing manager saying, well, I didn't know anything about the previous whistleblowing complaints, and therefore the dismissal when it comes cannot possibly be due to prior whistleblowing complaints because I didn't know about them. And the Supreme Court here on their unanimous decision say basically that's poppycock because of what a rogue manager does. So very briefly on the facts, this Jhuti starts work at Royal Mail, notices that some bad practices are going on, reports it to her manager. Her manager takes against this, starts subjecting her to detriment, it all goes rather south. Eventually, she requests a new manager, gets a new manager, but the previous manager is still in the background, manipulating like Blofeld things with perhaps not with one of those strange eyes. Sorry, spoilers for the new Bond film. When it comes to the new manager trying to dismiss the Jhuti for poor performance, she asks the old manager, well, what's going on here? And funnily enough, the old manager is rather, shall we say, careful with the truth, and doesn't disclose the fact that Ms. Jhuti has made protected disclosures in a proper way. And then ultimately the new manager dismisses Ms. Jhuti for it, and she claims automatic unfair dismissal, as you would. So it is slightly specific to its facts, but what you take away from this is A, rogue managers can get you in hot water. B, in a way, it is very hard to say this dismissal should be seen in isolation, and you need to look at the whole situation. And here, the whole situation clearly included prior whistleblowing disclosures. So in the situation here and going forward, you must always ask yourself, if you are advising you are the dismissing manager, what has actually gone on to lead me to this situation, and ask the probing questions. One would hope that none of us have rogue managers like we had in this case, Machiavellian-like people in hollowed out volcanoes working to the detriment of other people. But, you know, hey, these things happen. Kate.
Yeah, so our final case is our most recent case. So it's a September 2021 case. Involves an employee, Mrs. Kong, who is working for Gulf International Bank as their head of financial audits. So she raised some concerns about a legal agreement that governed one of their financial products, saying it didn't contain the proper legal protection and safeguards. And the issues that she raised in respect of that document, it was agreed by everyone, were considered to be protected disclosures. Where Ms. Kong went wrong was how she then handled herself after she had effectively blown the whistle. So she, the reporting talks about conversations about the issue. I suspect it was more of a shouting match in the office, is what it sounds like. So Mrs. Kong criticised her co-workers' professional integrity, and made accusations against colleagues personally in respect of this issue, to the extent that it seemed to lead to a real breakdown in working relationships. It seemed like a very unhappy team, with several people saying that they couldn't work with Mrs. Kong anymore because of the things she had said about them and how she had spoken to them. So it was in this context that the managers within the business decided that Mrs. Kong should be dismissed. Their reasoning related to her behaviour, her manner, her approach with people. Looking at all of that, they decided that she had behaved unprofessionally in her interactions with her colleagues. So in their mind, it was nothing to do with the fact she had raised protected disclosures. It was how she had behaved sort of after she'd raised those disclosures. Among some other claims that are relevant for these purposes, Mrs. Kong brought an automatic unfair dismissal claim for whistleblowing, as you'd probably expect. And ultimately, the decision was that the claim failed because the tribunal agreed that the decision to dismiss Ms. Kong was on the basis of her conduct in questioning her colleagues' integrity, and the manner in which she had behaved, which they agreed was unprofessional. And they were convinced by the bank's case that the protected disclosures formed sort of no real part of their decision to dismiss. So I think the lessons to be learned here are that it's not just because someone has blown the whistle at some point doesn't mean they're then, got a protective bubble around them forever, no matter how they behave or what they do. That said, this case is a good example of where there's a very clear reason which can be documented and is obviously separate from the protected disclosure. Quite often, as everyone here will know, it can be a lot grayer, a lot muddier, the facts in a particular situation. But I think it's also a lesson in doing those slightly boring process elements that us as lawyers often tell you to do, in considering reasons very carefully, having a really good paper trail, documenting exactly why a decision has been made and on what basis. Because if you have a strong case that a protected disclosure was nothing to do with a decision to dismiss or discipline, that's going to be really helpful and stand you in good stead if you do need to defend a claim further down the line.
Thank you, Kate. I have to say, when dismissing a whistleblower for a should we say, a supervening act or something else, tread very carefully.
Yeah, agreed.
Okay, just a bit of a wrap up on where we're going with whistleblowing in the UK. I don't want to put too much emphasis on that report from Protect about 1 in 4 whistleblowers being dismissed in that 6-month period. Now, I do find that somewhat troubling. But what we're not seeing is any appetite to reform whistleblowing legislation in the UK. So, although calls to do so, we've had OSPOF, which was a couple of £1 million. We have whistleblowing sometimes thrown in, but sometimes validly included in claims quite a lot, because it's a day one right and it focuses everyone's minds. So there's perhaps more to be done. So the last point on the slide talks about comparing current proposals to tackle workplace harassment. So right now we've got the government looking at a new duty, I'm sure you may be aware of this, for employers to prevent sexual harassment in the workplace, and that is to prompt employers to prioritise prevention of harassment. So we have the Equality Act at the moment, which governs how we deal with protection for people who have been subjected to discrimination. But the view is we need to do more post-Me Too. And so therefore we're going to put this positive duty in place. So this is analogous really to, do we need to have a greater duty in place to protect whistleblowers? Now it's interesting, the new directive doesn't go that far, but it changes the game in a number of respects, as Kate has talked about. I can see if there is weight behind this that we will go that way, but currently we don't seem to be going that way at the moment, despite calls to fundamentally review. So, Kate, what if we're in a multinational business?
Yes, so thanks, James. We can foresee if you have a business that is multinational, you cover various different jurisdictions, potentially the UK and a few different jurisdictions across the EU, that you're going to need to think strategically about your approach to whistleblowing and your policies. So as we've discussed, just taking, for argument's sake, the UK and the EU Directive on their own, the difficulty is you have elements under UK legislation which are broader, higher level of protection, if you like, than under the directive, and elements of the directive that are broader, higher level of protection than in the UK. So in effect, just implementing one or the other minimum requirements across all jurisdictions isn't going to work, because it's not going to meet the required standards everywhere. And that's before you even get to other EU member states' individual existing local whistleblowing legislation, which has various different elements of complexity and levels of protection as well. So if you are a multinational business, one school of thought is you complete an analysis of all the different requirements everywhere you're based, and implement one central overarching policy, reporting and feedback process that captures the most enhanced gold-plated version of the protection, because then you know it's going to meet or exceed the standards required everywhere. Benefit here is you've got centralised standards, centralised processes, potentially easier from an administration perspective, corporate consistency. The downside is basically that you're going to be enhancing in some jurisdictions a protection where you don't need to, and processes where you don't need to. And I think in particular, the definition of a disclosure could create issues with one single policy. because it could significantly enhance the protection that, for example, employees think is in place for them in certain jurisdictions. Just to caveat that, of course, your internal policy, particularly if it's non-contractual, can't override local legislation. So it doesn't necessarily mean someone could bring a claim for a different reason, but it might make the way you manage things internally more difficult if they think their protection is enhanced as a result of what the policy says. Another school of thought is to have sort of bespoke country by country approaches, individual policies and reporting channels that comply with the requirements in each jurisdiction. Benefit is that it will definitely meet all those local needs and doesn't enhance anywhere where it's not required. But it might make administration more difficult. There might be sort of a less coherent understanding of what the business's approach to whistleblowing is across the business. So we were talking, actually, James and I, about more of a middle ground, which I think it could work depending on resources within a business. So that's potentially to have one central set of reporting channels, confidentiality requirements, feedback requirements, so that you've got one overarching policy on how whistleblowing is dealt with from a process point of view and meets the highest standard in all jurisdictions that you're based, but to have country by country policies on scope of protection, who's included, what constitutes a disclosure, so that you deal with that issue of potentially enhancing where it might make your life more difficult. The other thing I think to add into the mix when thinking about cross-border issues is cross-border workers, and the difficulty if they cross two different jurisdictions where you have differing levels of whistleblower protection. Putting it really simply, the general rule is that where a person has the strongest connection, so where they mostly live, work, where they get paid, where they pay tax, that tends to be the local law that applies to them. So in theory, it should be possible to work out which policy would apply to a cross-border worker, unless they are someone who genuinely evenly splits their time between different jurisdictions. So it's always sensible to take specific advice if you're in that situation. I suppose that's where one policy, one process for everyone might be helpful in terms of cross-border workers, but query if it outweighs the downsides of gold-plating protections for everyone else. I think there's no one right answer to this issue, I don't think. I think it's got to be a strategic decision for individual organisations. It's probably going to depend on infrastructure, resources, how independent local entities and workforces are. Do they have their own in-house legal teams, senior management, HR teams that could handle an individual whistleblowing policy? What's the corporate culture like? Do you like things to be very consistent across different workforces? There'll be all sorts of commercial issues at play as well. Don't know if you had anything to add on that, James, following our discussion yesterday.
I did. I was just going to say, I won't do the Lord of the Rings reference that I did yesterday, because you just only get some of my cultural references. But I think it's really quite hard to have one policy if you are a business that is in many, many different jurisdictions, given these problems. And let's face it, this is one example in terms of whistleblowing. This is only going to get, I think worse is the wrong word to use, but the problem is going to get bigger as more European directives come through and the UK isn't implementing them. So it's going to pick up and be highlighted in other aspects of our working lives. So I think that's definitely coming. And actually, picking up on my last slide, we've been concentrating today on whistleblowing protections and then what happens if somebody is subjected to a detriment or there is a dismissal, and then all the stuff that flows from that. I'd like to take us back, if that's possible, which is, why are we trying to look at whistleblowing? We're trying to surely have a culture where people feel comfortable to say, this is happening, can we change it, stop it happening, do something differently, so that we are not getting to people having fear of reprisals. So it's an openness. So the culture, which has to be driven from the top, is that we want to know stuff. Tell us what's happening so we can fix it, so we don't have situations where people are being penalized later for saying things that would actually be things that we need to know about to be able to then work more effectively and run the organization better. So all of this is the legal stuff, but there's a massive role here for senior management and HR and in-house teams to be able to look at what do we do here to ensure that people can speak up easily with anonymity if they need to. You have your speak up line to get a better level of communication going in the workplace. And yes, you need your protections, and yes, you need your policies, but it's all about, for me, culture and transparency. I'm sorry, I'll get off my soapbox now, but it just seems to me that that's where we need to be. Rachel, I've got some good news. Nobody has asked for you to sing anything today.
Excellent. Shall we? I mean, obviously, some people have asked questions as we've gone along. Others may have waited until now. So, if anybody has got a question arising out of anything that we've covered this morning, can you just drop it into the Q&A box? Nothing there for the moment. I'm going to ask a question. Don't mind who answers it, James or Kate. What would be your advice if, to our in-house advisor community, what would be your advice if they take the view that there should be some enhancement, say, to an organisation's whistleblowing policy or reporting arrangements or something like that, and senior management are either completely uninterested in doing that or very resistant to improving the organisation's whistleblowing arrangements? Have you got any sort of practical tips as to how you might persuade senior management to take it perhaps a little more seriously?
Kate, do you want to take this or do you want me to?
Well, why don't I start it off and you can add some pearls of wisdom towards the end. So I would say, number one, it was actually something we discussed yesterday, which is you can tend to find that a lot of the cases we've talked about today are individuals who've raised protected disclosures and then alleged that ultimately there's been a decision to dismiss following the raising of a protected disclosure. It's followed quite quickly. But I would say in my experience, you can find what I would describe as slightly more spurious whistleblowing allegations where someone has almost seen lots of issues, building up over time, hasn't said anything about it. They might be put on a performance process, or they might get a sniff that there's some sort of disciplinary issue coming, and then suddenly they will come out with a load of sort of protected disclosures at that point to try to shore up their position. And in effect, I would argue that the more sort of gold-plated your internal whistleblower processes and protections are, the more likely it is that the issue has already been raised by someone else because they felt comfortable to. So you can say, well, we've already looked into that and this is what we've done to address it, which really reduces their leverage in terms of whistleblowing. Or you could have a much greater argument that they should have raised it previously, and it just makes it, I think, less likely that you'll get those sort of cynical whistleblowers at certain strategic points. The other thing is, I always think it's useful it's probably why we talked about it today, raise the Osborne case, because it can make senior managers feel slightly less comfortable that it's not just the organisation that can suffer in a whistleblowing situation. There could potentially be personal liability. So it really isn't something to be sniffed at, particularly by senior managers. I don't know if there's anything else, James.
You asked me if I had any other pearls of wisdom. I don't know if I do. I was going to say, think about, obviously apart from personal liability, it seems to me if senior management are not on board, they're being ostriches, they're intransigent and they're not going to change. I think the role of in-house counsel here is very much to say, okay, you're exposing the business or the organisation to risk here. These are some of the recent awards. So if we don't get this right, people, we are unnecessarily exposing this, and people are going to be raising issues not in a way that we can deal with them constructively. They're raising issues to gain protection later, and it all gets messier and more expensive. So at the end of the day, if we create the right culture, if we create the right transparency, we will hear about stuff and be able to fix it, rather than having, for example, rogue managers like in the Jhuti case doing stupid things, and the legal budget will be spent more wisely for one very good reason. Should we take one more, Rachel, and then finish? You're on mute, my dear.
Sorry, I'm on mute. It's the first time today. I usually do that all the time. There's one question in the Q&A box. Can only the first whistleblower be protected?
No, that's fine. The first whistleblower is protected. If there's somebody else whistleblows as well on the same thing, then they can also be protected if they're subject to detriment. Okay, should we wrap up?
Yeah, let's wrap up. Thank you, obviously, James and Kate, for a really interesting talk. Thank you all the attendees for attending, and thank you also to the team behind this, Christine, Kate, and today Leanne, who do all of the organising. Do please give us some feedback by clicking on the continue to survey button, I think it is, that will come up once we switch off the session. We are particularly interested to know, as I said earlier, what topics you'd like us to deal with in future. So do please give some thought to that. Thanks very much and goodbye.
Thank you. Bye-bye.
Bye.
Bye.